Hi there, everyone. It's 4 o'clock in New York. Big day of news. The investigation into Donald Trump's handling of government documents, including some of the country's most sensitive national security secrets, is moving in important ways on two fronts today. One involves the decision to appoint a special master, an independent arbiter, to review the documents seized in the search of Mar-a-Lago. The other involves the special master himself. There's a lot of news on both fronts today. Let's start with DOJ's appeal of the decision by Judge Eileen Cannon, temporarily blocking DOJ from using the documents seized from Donald Trump's residence. That appeal is now before the 11th Circuit Court of Appeals. Donald Trump's lawyers in that matter are calling for the court to reject DOJ's request. Their main argument is that DOJ has yet to prove that some of the records seized are classified, even though it is Donald Trump who has not provided a single shred of evidence proving that they're not, proving that he declassified any of the records that he kept at Mar-a-Lago for up to 18 months. Now to the other front, more immediate, the special master process itself. Just a couple hours ago, lawyers for the Justice Department squared off with Donald Trump's legal team for their first public hearing before Judge Raymond Dearie. He's the federal judge who was appointed special master to review the documents seized in the search of Donald Trump's residence last month. During this hearing, Dearie, who was Donald Trump's pick, his hand-selected suggestion to be the special master, told Donald Trump's lawyers to put up or shut up on claims that Trump declassified the records. Here's how Politico describes the hearing. Quote, Judge Raymond Dearie pushed Trump's lawyers repeatedly for refusing to back up the former president's claim that he declassified the highly sensitive national security-related records discovered in his residence. Quote, you cannot have your cake and eat it too, said Dearie. It's where we begin today with some of our favorite reporters and friends. Asha Rangappa is here. She's a former FBI special agent focused on counterintelligence investigations. She is also an attorney and senior lecturer at Yale University. With us at the table, we have enough for a dinner party, finally. Jonathan Lemire, Politico's White House bureau chief and the host of MSNBC's Way Too Early. Ryan Goodman joins us, former special counsel at the Defense Department, now an NYU law professor and the co-editor-in-chief of Just Security. And MSNBC legal analyst Andrew Weissman is here. He's also a professor at NYU and a former Justice Department prosecutor. Most importantly, though, for this conversation, he was in the room. He was at this afternoon's special master hearing. Do tell.
So let's start with some atmospherics,
please.
Which is the hearing was supposed to start at 2 o'clock. And at 2 o'clock, Judge Dearie comes out on the bench, like clockwork.
Oh, wow.
And that is Judge Dearie. There's a real tradition in the Eastern District that they are responsible. They adhere to rules and order. It was a prompt, efficient hearing. It ended at 2:40 with Dearie having given everyone an opportunity to be heard. But he also conducted it. It was like an adult in the room, and everyone had to behave themselves. So that was sort of the atmospherics. And there were, with one exception, which I'm sure we'll talk about, there were no histrionics on the part of either side. And in terms of the merits, the key is, it really was put up or shut up, but it was said with a lot of judicial, in a Judge Dearie way, exactly. And he, at the outset, made it clear. He said, you may have Trump team, you may have litigation reasons and strategy as to why you don't want to tell me or the world in a court of law that these documents are classified. That's fine. But if you don't do that, I have in front of me a prima facie case, meaning that the government has set forth sufficient evidence that these are classified. For God's sake, they bear markings that say they're classified. So he said, if you don't want to actually say anything at this point, that's fine, but I'm going to rule. And that was really the theme of the hearing, because at some point when they started talking about whether there would be a need for people to actually have clearance to see not just top secret documents, but top secret compartmented documents, Judge Dearie said, I may be able to decide this issue where I don't even need to see them. that we don't have to get into that issue. No, he didn't say that's what he's definitely going to rule. He wants to hear from the parties, et cetera. But it seems pretty clear in terms of his thinking that he's going down the road of, if these are classified documents and I have no contrary evidence, then that sort of leads to a conclusion, which is I'm not returning these documents to you. So if you don't put up, then you're not going to get the relief that you're seeking, which is to have the documents returned to you.
It also sounds like from what you're describing is even if you do put up, then the process begins. Because it sounds like the person that Trump picked, and there's some neat reporting in Axios about why he thought he would go his way. It's sick and twisted and very Trumpian. But he's a FISA judge. He knows exactly what we're talking about. Talk about what the sort of difference, you talked about the atmosphere, but what's the difference in terms of the legal arguments being made in front of a judge like Judge Dearie as opposed to Eileen Cannon?
Well, here's an example that goes to exactly what you're saying. He said, let's assume that these documents are presumptively classified. He wasn't going to go ahead and make a ruling. He said, it is the obligation of the government to make sure that these are not shown to people needlessly. That is their obligation. That is a completely different mindset than, when they were in Florida. And, my sort of euphemism, this is like you're not in Florida anymore. You are now
happens in Florida, stays in Florida.
Exactly.
I want to ask you about the exception. What was the exception when there were histrionics?
Yeah, so at some point there was a discussion about whether the judge would consult with the National Archives, NARA. And the government had submitted in its letter sort of a one line saying, we really encourage you to do so. Not a lot of meat on the bones about why. And Jim Trusty, frankly, the only lawyer who spoke for the former president, who, by the way, he kept on describing as the president and saying he's the president's lawyer. That's the one time I was waiting to see what Judge Dearie would do, because he went on a political attack of the archives. He talked about them being a political entity. The archives.
The National Archives.
That's like saying it's a political entity. Like my public library is a political entity. He seemed to equate what Sandy Berger did to being the archive's fault, that they wanted those documents to be taken. And so the argument was that the judge should not be consulting with such an overt political body as the National Archives. Judge Dearie basically said, I don't actually see the need right now to consult with them, so this is a moot conversation. But in his very polite way, he said, of course, I do think, you might be painting with a broad brush there.
Oh, wow.
Which was his way. I mean, Judge Dearie is no fool. He knows exactly what's going on. He called them out in an adult way. But that's the one place where I thought that Jim Trusty was not reading the room and decided he was going to go on a planned diatribe that clearly was coming from his client.
Tell me what each side, for the DOJ side, one, who was there? Is it a name that we recognize from the filings that we've seen? And what did they argue? And what did they want out of this hearing? And then do the same for me for the other side. Yeah,
great question. So there were 5 lawyers from the government. One of the lawyers was from the taint team, which was necessary because the judge needed to hear what the taint team was doing.
Explain that. It's the filter team? Is that the same thing?
Exactly. This is the filter team that had culled out things that were potentially attorney-client privilege. And so there was a report from that lawyer saying that, I separately have pulled out that information. We have given it to the Trump team already. We're creating an inventory of that. They handed the inventory actually up to the judge right in court. So the judge was very pleased. He said it's great to see progress being made. As the judge said, he wants to act with responsible dispatch. And maybe one backdrop to this is that what we learned today is that it was Judge Dearie who had proposed a 4-week schedule, not to the end of November, but 4 weeks.
Oh, wow.
That was faster just to be clear, that was faster than what the government had proposed, because the government's letter had talked about coming back in a few weeks with progress reports. And it's pretty clear Judge Dearie does not see this as complicated, that this is just not that big a deal. So anyway, going back to your point, the government wanted to report on the progress of the taint team, the so-called attorney-client information. And there was very little that the government otherwise had to do other than sort of report about having a vendor or certain mechanical things. The main person speaking was Julie Edelstein. I actually don't think any of the other lawyers really spoke of any substance. She was asked by the court about what happens if the 11th Circuit doesn't grant a stay. And interestingly, she said, we will have to get back to you because I'm confident we'll be looking at other appellate options, which means the Supreme Court.
So DOJ is preparing to appeal to the United States Supreme Court if they fail in the 11th Circuit?
Well, she didn't quite come out and say that, but it was hard not to
deduce.
Yes, yeah. It was clear what she was saying is this is so important to the department that I'm not sure we'll leave it there. Obviously, they would have to see the decision and make an evaluation, but I thought that was notable. And it was basically telling Judge Dearie, don't count on this being, if the 11th Circuit rules against us, don't count on this being over so quickly. So that was basically it from the government side. Jim Trusty did all of the talking for the Trump team. And, he had a tough sell here. He was doing something that is very typical of lawyers in a criminal case, and that is delay. It's famously been said by Edward Bennett Williams that in a criminal case for a defense lawyer, an adjournment is an acquittal. And so, this is not new to Judge Dearie, which is Jim Trusty kept on saying everything's premature, we need more time, it's going to take a lot of time. Everything that was being proposed, he kept on saying why things were going to take longer. It's very clear Judge Dearie is not going to have any of that. Judge Dearie made it clear after he heard from both of the parties about his proposed schedule, that is the court's proposed schedule, he is going to issue an order. And that's, Judge Dearie is no pushover. He is going to have an order. He's going to expect everyone to adhere to it and make rulings. So I think that's what the court was trying to get out of this.
And just one more question, just to make sure I understand the process and what was on the line today for the government. If his ruling is to sort of express satisfaction with the work of the filter team or the taint team, does the investigation, the criminal investigation and the national security damage assessment proceed in that 4-week schedule? I mean, is the best case scenario those 4 weeks or how long we wait until the criminal investigation into Trump and the national security assessment can proceed?
I think there is a potential for it being even faster. I would say if Judge Dearie adheres to the 4 weeks, I'd say that's the worst case scenario.
Oh, wow.
That he is contemplating that from his perspective, it will be done. Now, it is important to remember that whoever is the losing side, and potentially they're losing, each side could have something they want to gripe about, they get to go back to Florida, and Judge Cannon gets to, consider those issues. I have to say, I've always thought with Judge Cannon, subcontracting this to a senior respected Article III judge, I think it would put a lot of pressure on her if she was thinking of reversing his rulings, because he's a kind of judge that no matter which way he rules, we're going to be thinking there's a lot of merit to it.
And she selected him ultimately, right?
Exactly.
She selected him perhaps because he was on a list provided by Donald Trump. There's some interesting reporting in Axios about why Donald Trump might have liked him. Quote, lawyers and advisors to the ex-president believe Dearie's role on the secretive court that approved controversial warrants used to surveil former Trump campaign aide Carter Page in 2016 and 2017 made Dearie a deep skeptic of the FBI. Dearie was one of the judges who signed off on the FISA warrants to surveil Page. 2 of the 4 approved warrants were later declared invalid after a DOJ IG report found a series of misstatements and omissions in the FBI's applications to get the warrants. Trump's lawyers are betting that made Dearie more skeptical of the FBI than an average judge in a way that endures beyond the Page case. I think that this could be seen as delusional and strange. Now, this is a team, though, that found Eileen Cannon. So tell me how Team Trump's judicial forum shopping is going in your scorecard.
So I think they've royally backfired on themselves.
With Dearie.
With Dearie. I mean, Dearie is a judge's judge, and we're refreshingly back in a forum that looks and smells and tastes like the rule of law and a judge running a courtroom in the right way. So their speculation based on the Carter Page FISA applications is a bit nutty, and that they could in fact generalize from that to think that he has now a disposition against the FBI in such a way. And he's obviously not that kind of a character. I think he's just abiding by the law, and he's very sensible in his understanding of national security concerns and expediting this process. I'm sure that's also weighing on him. So I think the idea of Dearie is actually a fantastic favor, in a certain sense, to the rule of law, and that we'll see how this operates under his care. But as Andrew says, then it goes back to Judge Cannon, and she could overrule him. She has that power. But right now, I think things are on the right track. Let's put it that way.
And what of what happened today either reassures you or troubles you?
So I think the part that reassures me the most is that he gets it on the classified information. He's not giving the Trump side any excuses, in a certain sense, that it is time for them to pony up. If they want to make a claim that they declassified any of these records, they can do it. But if they don't want to do that, then he has to default to the judgment of the intelligence community that they've already put classified markings on all these documents. Any other judge in America, I think, would do the exact same thing, essentially, which is say this information is classified unless you want to come and tell me that you did something different, and I think they don't. It seems as though they don't want to ever make that claim in a court of law where they would be subject to penalties and federal crimes of lying to a court. So I think that's the most sensible thing. And then, as Andrew says, we have this 4-week schedule, but one other benefit of the order from Judge Cannon is that she said that he has to prioritize the 100 classified documents. So if he does that, if he issues an interim ruling, she also gave him the power to do that, we could put the criminal investigation back on its footing, and we could put the intelligence damage assessment back on its footing with respect to the 100 classified documents, and that would be really important for U.S. national security. That is the urgency of the current situation.
Asha, when I think back to the alarm that was felt by every single sort of anyone that had ever touched any part of U.S. national security, either military or FBI or DOJ or CIA, and in talking about these lags, this inability to proceed with the criminal case, which is inextricably linked in the national security implications for the country. I wonder your reaction to today's development, and not that they're dueling, but these two judges that are now the prominent figures in the matter, Judge Dearie and Judge Eileen Cannon.
Yes, Nicole, I think what we're seeing is just the importance of a judge who not only understands the law, but is willing to apply it. I mean, you can only imagine if in the post-election cases, if judges had been willing to entertain unfounded assertions of voter fraud. I mean, we would have gone down the crazy rabbit holes that we saw Judge Cannon go down. And here we have national security issues at stake. And I think one of the big miscalculations the Trump team has made is that precisely by virtue of being on the FISA court, remember, the FISA court is created in recognition of the fact that the executive branch has national security obligations that are so important that they can even override certain civil liberties concerns, that this balancing act can tip in the government's favor. This is what Dearie understands, and this is the mindset that he is going into as he's approaching this. I think that, it doesn't erase the critical importance of the time needed to actually interview witnesses, find out who these documents could have been disclosed to, and what potential, might be, what documents might still be missing, for example, that could still be exposed. But I think Dearie understands that, and hopefully will move forward quickly.
I want to turn to the criminal case against Donald Trump. There's some interesting reporting today by Maggie Haberman in the New York Times that, again, goes to Trump's knowledge that what he was doing was illegal at the time. one of those elusive pieces of the Trump puzzle for the 6 prior investigations we've all covered together. The Times is reporting this. A one-time White House lawyer under Donald Trump warned him late last year that Trump could face legal liability if he did not return government materials he had taken with him when he left office. It's according to 3 people. The lawyer, Eric Hirschman, sought to impress upon Trump the seriousness of the issue and the potential for investigations and legal exposure if he did not return the documents, particularly any classified material. Trump thanked Hirschman for the discussion. Can just picture that, right? Good talk. But was non-committal about his plans for returning the documents, people familiar with the conversation said. So he said, you know, you say tomato, I say tomato, I'm keeping it. But he was warned, and that is on the record, and that is now a witness at the disposal of the Department of Justice.
Yeah, I imagine it was an abrupt goodbye from the former president there. Hirschman, of course, used to work in the White House. He's a name and face probably familiar to a lot of viewers because we saw from him during the January 6th committee testimony. He spoke then as well. But this is another piece of evidence, another, as you say, possible witness for the DOJ as they piece together that Trump knew that he had material he should not have had, and he hung on to it anyway. Now, this can't be part of one of the original. Remember, they've thrown so many stories and excuses up against the wall, one of which being, oh, other people threw stuff in boxes the former president didn't even know it was in there. Well, it's clear that he has now been warned by a reputable person that, in fact, you have material you should not have. You should have classified material. He should not have had that at any point. And this just adds to a case that is painstakingly being built. One delayed now, briefly, it seems like, because of what's happening with the special master, but perhaps not that long. And I think from the DOJ's perspective, this doesn't change their timetable that much. We do not know if there will be an indictment. We do not. But all along, the sense has been that it would be after the midterm elections, that even though Trump is not himself on the ballot, that they would adhere to that 60-day guideline to not have any sort of overtly, what could be perceived as an overtly political prosecution, because Trump is still the sort of dominant figure in the Republican Party. That doesn't seem to change here. And that this is just another piece that even if Trump's lawyers are successful in bogging this down a little bit, when that's been their go-to tactic throughout, delay, those delays at the end of the game may not help very much.
Yeah,